Hey everybody, it's Joel Williams and attorney Jared Easter here at Williams Elleby coming to you with another video. And today we want to talk about what you need to look at in the process when you have to sue the federal government or any of the entities within the federal government. Personally, I try to run away from those cases as fast as possible because there's so many different intricacies. However, Jared has joined us for almost a year now, and he's got some pretty good experience suing the federal government and the different steps you have to go through. One thing to be aware of right out of the gate before we get into the federal government claims is that there's a big difference between suing the federal government, a state government, a county, a city, and all of those things as far as state, county, and city varies from state to state. So if you are injured by any kind of governmental entity, it's probably going to be in your best interest to reach out to an attorney in the state where you live that has experience dealing with those type claims, because there's a lot of procedural loopholes that you have to know about. If you are in the state of Georgia, we do have a previous video over suing state, county, and city governmental entities for the state of Georgia, and Shannon will go ahead, our video editing lady, will go ahead and put a link to that video in the description below. So this video is limited to federal government claims. So Jared, what's the first thing that you look at when you're looking to sue the federal government?
So I think it's important to start with just talking about what immunity is and why these claims are complicated. At its base, the federal government has immunity from being sued, which basically means they cannot be sued for negligent acts of their employees. However, there's a congressional statute that was passed called the Federal Tort Claims Act, and the Federal Tort Claims Act waives that immunity in certain situations. So it basically provides a framework for where injured people can bring a claim against government entities, subject to some certain loopholes that they have to jump through and make sure that they comply with, or else their claim will be barred.
Gotcha. So what are some of those exceptions? Like, what if somebody's injured, what's the first thing they look at to find, like, can I even bring a claim? And what are those situations where I can't?
So generally, it's not so much whether you can or you can't. It's just that you first of all need to identify whether it is a federal entity and a federal employee working within the scope of their employment as an employee of the federal government. Contractual workers or 1099 employees are not covered by the Federal Tort Claims Act, and they are subject to liability through normal state functions, depending on where the negligent act occurred and what company they actually work for. So as long as it's an employee of the federal government, then it falls under the Tort Claims Act, which provides a lot of different things as far as what can and can't be done.
Gotcha. And I'm thinking that just things that first pop up in my mind are a mail truck, or somebody gets hurt at a military base or anything like that.
Correct. Or I think another common one that comes up would be a malpractice claim involving a doctor at the VA hospital. The Department of Transportation, in limited circumstances, the federal government is responsible for road design. So you might have a road design defect case where it's not the State Department, it's actually the federal government, maybe an interstate or something along those lines, that designed effectively and ends up causing an accident with injuries. Or it could be something as simple as an employee of the EPA who has a company vehicle, and we're just driving from one site to another and just get in what appears to be a really kind of run-of-the-mill car accident. You get the accident report, you realize that that person doesn't own the vehicle, it's actually owned by the Environmental Protection Agency or one of the other tons and tons of federal agencies out there.
Okay. Now, one thing I've heard from a lawyer's perspective, and most people know, and if you don't know, most personal injury attorneys work on what we call a contingency fee basis, which means that the attorney is paid a percentage of whatever the ultimate overall recovery is. And those percentages may vary from law firm to law firm or from case type to case type. But I have heard that those legal fees are capped at a certain amount in claims against the federal government. Is that right?
That's true, and that can be both good and bad for plaintiffs. The fees are capped for a pre-suit case, meaning it doesn't have to go into litigation. They're capped at 20%, and then if the case does have to go into litigation, it increases up to 25%, but it caps them there, which is considerably less than what kind of the standard rates are for personal injury cases, which as a consumer is a good thing. Everybody hears lower prices, they think, wow, that's awesome. However, in more complicated matters, what you can potentially run into is a medical malpractice case against a federal doctor is going to take a lot, as you well know, a lot of time, a lot of effort, and just a lot of experience, manpower. There's a lot that goes into those cases. And sometimes an attorney might be less willing to sign up for 5 to 6 years worth of kind of hard legal battles for such a low fee rate that's so far off of what they're normally accustomed to. So it can be good and bad.
Yeah, I mean, I'll tell you right now, I'm not touching a medical malpractice case for 20%. Like, it's the amount of hours that you have to put into it and the amount of money, your own money or your law firm's money that you have to put into it, to knowing full well that, the majority of medical malpractice cases result in a defense win is just not worth it from a business perspective. And so it would truly have to be an exceptional case in order for, at least for me, to be willing to do it. And I'm sure there's plenty of attorneys out there that would be willing to do that, but it's much different than if I'm looking at a medical malpractice case versus a mail truck runs into the back of somebody. That's a whole different ballgame. You can probably work that one up in a way to where it makes sense financially, both for you and for your client, to work that case. All right, so I know in state and county and city claims, at least in the state of Georgia, there's what we call an ante litem requirement, which basically means that within a certain amount of time, you have to put that local government on notice and follow specific statutory framework to tell them what the claim is, the basis for your claim, how much you're claiming, the injuries and all of that. Is there anything similar to that for federal claims?
There is. I think it's commonly referred to as a notice of claim requirement. It's similar but slightly different in the way it's handled. It requires, there's actually a form from the government called a standard form 95. That form has to be submitted to the governmental agency that the alleged negligent act occurred with. And in that form, you kind of spell out what the injuries are, what the alleged negligence is, the alleged agency that committed the negligence, and then the amount of damages that you're seeking to obtain on your behalf for the alleged injury. And what's different from kind of the way all claims in Georgia work are you basically have to include all the information for all the sorts of damages that you have, whether it be property damage, personal injury, lost wages, whatever you allege you've incurred has to be included in one letter to the agency all at the same time. And this is where it gets tricky, because the letter is very detailed and it does require certain things be done in a certain order, the timing, everything's very specific to prevent your claim from being barred because you didn't follow the correct steps.
Gotcha. So it is very strict as far as if you miss one step or do one step incorrectly, it's similar to the state government claims where your entire claim could be barred.
Correct. And the big ones are getting it to the correct agency. I mean, that one seems kind of easy to me. It's important to have a good attorney to figure out and make sure, like in the EPA example, you think it's just a lady driving a car. It turns out your claim's actually against the Environmental Protection Agency. But more so, and this one will probably give you nightmares, but it's the damages. You have to, whatever number you put into your standard form 95, that ends up being the most you can ask for at trial. So if you're early on, if you send it too soon and you ask for, $100,000 and you end up having another $300,000 surgery, the ship has sailed. Now you're at trial asking for no more than $100,000 despite having more in injuries. So that's one of the hang-ups where you can really get caught up, and you need to be well prepared in advance to make sure you don't have that mistake.
Gotcha. So I could see where that could become a problem if you've got someone who's seriously injured and they have extended treatment. And this is a good question for you, is there a time limit to when you have to send that notice?
Yes, and that's where it gets even more difficult. You need to, so unlike Georgia's statute of limitations where there's 2 years to file the lawsuit, you have up to 2 years to send the notice of claim to begin with. So you have 2 years to send the claim to them. And then this is where it gets extra complicated, so bear with us. You have 2 years to send the form. The government then has 6 months to review your claim and decide whether they want to pay what you're asking for or pay a different amount or pay nothing at all. So 2 years to file the claim, 6 months for them to review it, and then when they make their decision within the 6-month period, you now only have 6 more months to file your lawsuit. So that means if they don't take 6 months, they take 3 days to review it and deny it, your 6-month clock starts ticking then. So from that point forward, you have 6 months to get your lawsuit filed, go to trial, and ask for the number that you put in your Form 95. But then also, they don't have to respond. So you can send the letter to them, wait the 6 months and never hear from them, but at the 6-month mark, it's deemed to be rejected. Now you only have 6 months left to file your lawsuit. So there's a lot going on there, and you got to really thread the needle to get it all done correctly and timely.
So it sounds to me like if you have a client who's not done treating and you don't know the full extent of their damages, when the time limit comes to send this notice, you better overestimate what the damages are going to be.
Yes, I always would say demand really high, because you can always come back. They can always offer you a fair number below, but you don't want to be in that situation where you have sent the request too low and kind of boxed yourself in to where you can't get what you really need at trial.
Gotcha. So where do you even send this notice? Am I sending it to like the president or the Speaker of the House or like some department head at an agency? Where do you send them?
So yet again, that's kind of obvious. It could be the $1 million question. Where does it go? You're supposed to send it to the agency, which then becomes its own, for me, my own personal nightmare of knowing who is that person, where is that place. You know, for the Postal Service, I remember when I was a young lawyer trying to figure out, where do I send it? Do I send it to the Postmaster General in Atlanta? Do I send it? And eventually, and I don't recall offhand, but there is an address. You can dig into the website for the post office and you will find, kind of buried in the fine print, this is the legal department where it goes to. And presumably every federal agency has that department. Me personally, I send it to everybody. I will send it to 10 different places just to make sure. I'll send it to the postmaster, on up the chain, the person themselves, anybody that looks like is a director. We've all done it with anti-items. You're just like, I might send it to the president if I didn't know where else to send it, because why not? But specifically, it's supposed to go to the agency that is alleged to have committed the negligent act. And sometimes, again, it just takes a lot of digging and trying to figure out exactly, where that place is. But again, another reason to have a good attorney that will spend the time looking and get it to the right place.
Gotcha. All right, so that's a lot of pre-suit stuff we've talked about. When you file a lawsuit, assuming the offer comes back and it's not fair, or they wait the 6 months and they don't make an offer and it's deemed rejected, is there anything that people need to know about the actual lawsuit process, like where you have to file, and is there any differences in the actual litigation portion of the claim?
There's not a lot of differences. It is a federal claim, so you do have to file it in the district court of where you would normally file. So it would be the Northern District of Georgia if it happens to be in the metro Atlanta area, or north southern, just depending exactly where the the accident or alleged negligence is located. But past that, it really operates as a pretty much a normal, federal court case.
Gotcha. Okay. Anything else that these good fine folks need to know about federal claims? And
No, that's a lot of information. It is complicated. The big thing is just to make sure that you do try to identify it as early as possible if you do happen to get into a situation where there's some negligence on behalf of a federal agency, and then get a trusted attorney involved that can kind of dig through the details and make sure that all the I's are dotted and T's are crossed.
all right. Awesome. Well, thanks for joining me today, Jared. And I'm sure you'll see Jared, to his great chagrin, on future videos on topics that I don't know as much about. But we appreciate you spending some time with us today. And if you have been hurt by the federal government or an agency within the federal government, I think the biggest takeaway from this is find an attorney that's dealt with this stuff before, and let them handle it so that there's not a procedural hiccup that will destroy your entire claim. But otherwise, if this video has been helpful to you, give us a thumbs up, subscribe to our channel, and we will see you next week.